This is Aaron Owens. He came to court right after JB sentencing. He walked in. I cut my camera off, but I cut it back on as soon as I discovered what his charge was. He'd been in the Michigan Department of Corrections for 14 years, but recently was caught with 309 grams of, just listen.
And explaining everything, and I was willing to come down to this specifically only person who possessed of contraband. But Your Honor, this was 309 grams of meth that was found within the prison. That's a significant amount. Not only that, but Mr. Owens had it stashed in another inmate's cell to try to distance himself and only have semi-culpability if that was happening. Thankfully, the investigators in this matter asked for DNA. They did DNA, and out of the 8 spots where DNA was found, 7 of them were of comparison value, and all 7 of them had Mr. Owens' DNA on them. All 7 different spots, that's inside, outside knots. 3 of the bags were big chunks. 1 of the bags had 14 individual prepackaged corner-type baggies in it. That to me is so indicative of delivery. But again, we're here on an offer that his attorney managed to get him, and we have to focus on the crime we are, but that doesn't change what contraband was in the prison. It doesn't change the value or the amount of contraband in the prison. And I think Mr. Owens is very culpable of what he did here, and I think for that reason, Your Honor, the court should be to the middle or top of the guidelines on this matter.
All right, Mr. Neighbors?
Judge, on page, this was a 22-page overall PSI, which included the updates with this case, as well as this old PSI from Recorder's Court down in Detroit. In the PSIR, Judge, in the sentencing information report, that I'll submit to the court that Aaron's ultimately the acceptance of responsibility for the seriousness of what he did is contained there in OV-19. We spoke before about my likely challenge of that under the facts of these and circumstances of this case to further bring the guidelines down even lower. In discussing with Aaron, he indicated that, look, the bottom line is I understand how serious this is because there were drugs in the facility. So that's why I'm not challenging the scoring of 25 instead of 10. Now, this is a very difficult case, Judge, insofar as I think the court can use its both now judicial experience, but also prior now as a defense attorney to understand the situation that my client finds himself in. He's serving a lengthy prison term. He's in prison, and I know that this court knows that sometimes things happen. Should they? No. Do they happen all the time? Yes. Is it part of that culture? Yes. Is it something that we should just shrug our shoulders and say, so what? No. But we can't always look at stuff, with a holier-than-thou perspective. He found himself involved in something, but he was certainly not the individual running this operation. And I think ultimately the people understood the magnitude of what I'm about to say here as to how we got to this resolution. The individual running this was a prior correctional officer. For my client to ultimately cooperate against that guy was not something that he could do. It was just simply too jeopardizing to him in the fact that he's still going to be housed with MDOC through 2034. So ultimately this was a scenario where Mr. Owens was put in a lose-lose situation insofar as he always wanted to take some responsibility for his actions, but was also met with heinous guidelines, as Ms. Jonas has already hinted, plus a scenario where you can help yourself by cooperating, which would have led to other heinous consequences for his well-being. So I guess in some strange, and hopefully the court isn't offended by this, in some sort of strange backwards way, I'm asking the court to ultimately find praise in my client's ability to take the responsibility for what he did in accepting this plea, understand that of course there's some benefit to him, but also finding the fact that, ultimately praise was probably the wrong word, but maybe just understanding that ultimately the bottom line is this: he didn't snitch because he couldn't snitch. And the ultimate person of interest was the person running this ruckus that he found himself in. Again, there's no excuse for that. He stands before you. He knows he's going to get a consecutive sentence on top of what he's already doing. He was already serving 23 and a half to 46 years. So his choices are not excusable. He understands that, you know, he needs to just simply focus on those people that are waiting for him to come out, the people that ultimately helped me counsel him into taking this plea offer. And the last thing I'll say, Judge, is, you know, I handle a lot of cases, probably at times too many. Aaron is a really pleasant individual who, while the paper says things about him, the nature of his earlier convictions, he genuinely did the proverbial jump in the deep end for his first serious criminal contacts. Now he does this stuff in prison. But he really is an intelligent person, someone who is, I believe, well-intended to come back in the community, fully rehabilitated, despite the fact that now he's got this stigma associated with, you know, being a prisoner in contraband. But I genuinely believe that this was ultimately the best thing for him. He understands that, and he's looking forward to having the second part of his adult life as a free person with a focus on doing the right things on the outside. He found himself doing some things on the inside that are certainly not right, but I think now especially he fully understands that the difference between just because things happen, you got to find a way to not get yourself involved just because the culture says X, Y, or Z, or the respective facts and circumstances say, yeah, it's okay. He's doing it, she's doing it, I'm going to get this little benefit. So with all that, Judge, I think, you know, given the fact that he's getting no credit for this, certainly, again, that's because of his actions. The guidelines being 14 to 36, I would ask that the court, you know, consider the overall facts, the circumstances, the fact that in many ways he couldn't do more than what he did by taking this plea, just by way of self-preservation, and sentence him as the court finds fair and just, hopefully closer to the first number than the latter. Thank you.
All right, thank you, Mr. Diegos. All right, Mr. Owens, anything you want to tell the court prior to sentencing?
No, Your Honor.
Okay. Well, this is the way I look at it, okay? You know, there's mitigating circumstances or aggravating circumstances. The court certainly appreciates the fact that Mr. Owens should accept responsibility for this, albeit a no contest plea, but that's because you know, we take it as a guilty plea. Mr. Diegos is correct. I'm not naive to the situation in the prisons, the fact that there would be some significant consequences to you if you weren't, in fact, to cooperate with the prosecution. My hope was that you would, only because it's frustrating that somebody who we put in a position as a Department of Corrections officer who we expect and to keep order in the prison is part of this whole thing. But there's a lot of aggravating factors here. The quantity of drugs is significant. You know, we try to keep our prisons free from drugs. Contraband, I get it, there's plenty of stuff in there, but, you know, Mr. Diegos is correct. You know, we can't just go, well, it's gonna happen, it happens. I can't do that. The minute we start saying, hey, look, you know what, recognizing that this stuff happens and we can't stop it, we lose all control in our prisons. We can't do that. So, certainly, you got some benefit to this. I would be shocked if you didn't have some significant benefit in this whole thing. And that is an aggravating factor. The fact that, again, the significant quantity here is something the judge or the court can't ignore. You know, this quantity would tend to lead the court to the top end of the guidelines only because it's a significant quantity. We have prisoner possession of contraband. Well, what's the nature of the contraband? Well, a whole heck of a lot of drugs packaged to look like for sale and distribution inside the prison in conjunction with somebody who is out on the outside. It's a little bit different than somebody just tossing footballs over the walls. This was a conspiracy, and it involves two people to get drugs distributed in the prison. So, but again, the fact that you accepted responsibility for your actions, the court does recognize. So I don't think the top is appropriate. I also don't think the bottom is appropriate. But the court feels that somewhere toward the middle top is where I'm at, given all the facts and circumstances of this case. So the court is going to sentence you. And the court is also considering the fact, although I can't give you credit, the fact that you have been sitting on dead time is also a factor in it as well. So the court is going to sentence you to 28 months to 7.5 years, Michigan Department of Corrections. Again, there is no credit. This charge is consecutive to any sentence you're currently serving in the Michigan Department of Corrections. You do have a right to file an application for leave to appeal your conviction and sentence if you're financially unable to retain an attorney who won't be appointed to a public expense. Request for assistance to a lawyer must be made within 42 days from today's date. Mr. Weaver is handing you a form that you must complete and return to the court in that 42 days if you wish to request the appointment of an attorney on appeal. Wish you luck. We're adjourned.
Thank you.
Thank you.